kick off with a couple of things, and then Mark's going to give you an idea of the kinds of inquiries that we've been getting in this coronavirus period. And then, unfortunately, after I've finished, or rather after Mark's finished, and I'll just summarise things, I'll have to leave the meeting. I've got a virtual court date this morning. Which is quite a bizarre thing, sitting on the end of a telephone line. It's not even audio visual, and listening to everybody in the courtroom and trying to work out who's who, and especially not talk over the top of the judge. So it's a brave new world, certainly. Okay, so well, with our brave new world, I noticed the NBA has been putting out quite a few messages about how to survive in coronavirus and how it affects the building industry. Those of you who are members of the NBA will no doubt be getting these. And given that we're having this virtual meeting, and obviously people aren't travelling to the meeting, I thought I would mention that the NBA, but of course you guys have to travel to do inspections and so on. The NBA has put out a flyer just talking about whether their members are permitted to travel to and from the work site under the current government restrictions. The short answer is that yes, you are. Building and construction industry is officially recognised as an essential service, so you're allowed to travel to and from, as long as you still observe hygiene and social distancing guidelines. Now, the NBA has actually done a template letter for your employees. It's probably pointless doing a letter for yourself if you're a sole trader, but if you've got employees who are out there, they've drafted a letter that you can give to your employees in case they're pulled over by the police, just to confirm that they're working for a company that's involved in the building and construction industry, and therefore is not in violation of the rules. So you might think about that if you've got any employees out there, or if you yourself are out there and you get pulled over by the cops, you can tell them you're in an essential industry, and hopefully they'll listen to you, and not it won't be like the excuses you give when you're a few kilometres over the speed limit. In terms of good news, if there's a bit of good news around at the moment, the state government has, like the federal government, have been shoveling taxes and fees and stuff around. Relevantly to our industry, your industry, from the 15th of April 2020 to the 14th of April 2021, 1-year building contractor licences, trade and specialist contractor licences, their fees have been waived. If you've got a 3 or 5 year licence renewal, the licence fee will be discounted by a year. 2-year demolition licences, fees are being waived. And also home building qualified supervisors certificate licences being waived for a year. Home building tradesperson certificates, those licence fees are being waived for a year. And where, again, you've got longer licences of longer durations, it gets discounted by a year's worth of fees. So the state government's helping there. So if anyone's still got a builder's licence, you don't have to pay fees for this year, for the next year. Now, obviously, a lot of you guys are still out there working. I think Dominic said these guys are out there 6 days a week. And for obvious reasons, the government is trying to stimulate money flowing through the economy. And one of the ways they're trying to do that is by relaxing some of the rules around construction, and in particular around when you can construct. Most of you will, and work, so most of you will know that usually when you get a development consent, you're restricted to working Monday to Saturday and between certain hours, and there's different parts of construction work that you can't do, particularly on weekends or early or late. Well, the government's decided, the state government has decided that you need to be working and able to work longer than that, because you're probably going to be slowed down due to supply issues, just getting people on and off site, social distancing, you can't work too closely together and so on. So what they've done is, as of the 2nd of April, they've passed the Environmental Planning and Assessment COVID-19 Development Construction Workdays Order 2020. It's quite a mouthful. Pursuant to that, what they basically said is, doesn't matter what the council said in your development consent, you are now able to work, and that means building work and demolition on a Saturday, Sunday or public holiday, regardless of the development consent. Now, there is an obligation to take reasonable steps to minimise noise on those days, and there are certain types of work like rock breaking, rock hammering, sheet piling and so on, which aren't permitted to be performed on those extended days. But otherwise, so that productivity can be kept going as far as possible, given that construction and development apparently make up about 10% of the New South Wales economy. They've pushed that forward. So about 400,000 people employed in the property and construction industry, and so they're trying to keep them working, but also safe and healthy. So hopefully, with the availability of those extra days on which you can work, we won't have too many late completion claims and delay claims because contractors haven't been able to finish jobs before the contractual date for practical completion. Now, contract, that raises a question about, well, how does coronavirus affect your contracts? And we've certainly had a lot of questions in our office about contractual provisions and two things that didn't previously come up too often. One's frustration, and the other one's a delightful French phrase, force majeure. And you guys may have heard a bit about that when you've been out and around and talking to people. So what I'm going to do is flick over now to Mark, he's going to take it up on what we've been hearing in our industry relating to building and construction. Mark, over to you.
Thanks, David, and good morning, everyone, and thanks for the opportunity to come along again. So, as David said, construction has been continuing on unabated, with albeit under this new environment, and we're getting a number of inquiries both from subbies and contractors and developers in and around issues such as extensions of time, payments of delay damage, excuse me, and also rights of suspension. And as David said, people have a vague idea of this concept of force majeure and wondering whether it applies to their current contracts. They're the sorts of areas that we are seeing and fielding inquiries from, not only from those that are parties to construction contracts, but also parties that are subject to general supply contracts. So you might have a developer who's entered into a waste contract, or a principal of a business with a waste contract where the business is no longer trading, and the waste services are obviously not required, just by way of an example. So what I'll talk about today is obviously construction related, but it's equally as applicable in some of the instances where we talk about things like rights of suspension and things to other contracts that you or your clients may have entered into. So, as I said, the first one is we're getting a number of inquiries for claims for extensions of time, primarily as a result of delay in obtaining supplies. There was a significant hold-up, as we all know, out of China, where a lot of product, particularly facade systems and vertical transportation systems, are manufactured and shipped in. What we understood from there is initially that the factories were closed down, and then all the various provinces in China imposed their own restrictions. And so when the factories were able to get up and running, there was a problem in actually getting the goods down to the port, because they had to travel through a number of provinces, and at each of the borders, there were checks being undertaken. And so we were told some stories of a number of trucks that were sort of parked up alongside of the road, unable to get into or out of the various provinces once the factories had got up and running to actually deliver these goods to the ports. We understand now that there is still some, obviously, bottleneck in and around a lot of the major ports, which is obviously causing delay in getting supplies into our country here. And this is causing problems, obviously, for contractors that are under contract with dates of practical completion or dates by which certain equipment or plant has to be delivered and has to be installed. We're also, where there's access to site issues, obviously that is also giving rise to questions as to whether or not contractors or subbies are entitled to an extension of time. The answer as to whether you are entitled to an extension of time really goes back to the terms of the contract. So often in a lot of our commercial contracts, there are qualifying causes of delay. So typically a contractor would get an extension of time for an act or omission of the principal, for a delay caused by variation, latent condition, or an authority. In the residential contracts, the HIA contract and the MBA residential contract, we find clauses that entitle builders to an extension of time for delays that are beyond their reasonable control. So that's a fairly wide and fairly broad entitlement to an extension of time, which you find in these standard form residential contracts. We find that in the commercial contracts, we tend to be a bit more specific about what will give rise to an entitlement to an extension of time, rather than just something that is beyond the control of the contractor. But I suppose that then begs the question as to whether something is actually beyond the control of the builder, or whether or not they were tardy in making certain applications for certificates or permits, and whether that can then be said to be rightfully beyond the control of the builder. But certainly in the current COVID environment, what we're seeing is extensions of time primarily out of the supply of materials. And again, as I said, depending on your contract, will determine whether or not you're technically or contractually entitled to an extension of time. What we all know then, obviously, is the ramifications of not meeting a date of PC is obviously liquidated damages come into play, and those are payable. And so we're seeing with some of the larger principals, there's obviously threat of liquidated damages hanging fairly heavily over the heads of contractors and or suppliers to significant developments. Then in some contracts, then next issue that gets asked of us is, what about damages for delay? So damages for delay we'll find in the contract. We'll find whether or not the builder is entitled to a delay damage as a result of an extension of time or a delay in meeting the date for practical completion. Again, in the various residential contracts, there are clauses that entitle the builders for damages for delay, or in other words, entitlement to claim their costs of delays that arise as a result of a delay that gives rise to an extension of time. Sometimes in contracts, those delay damages might be capped at a certain daily limit, or depending on the negotiations, delays might be capped at a certain limit in the aggregate. And so these are things that maybe in other times when we're in a more normal environment, maybe the question of the amount or the extent of the delays may not be of some concern, because we had some certainty as to what are the likely issues that may or may not arise. But I think in this one, this is an issue that really has come out of nowhere, and likes of which, as we all know, we haven't seen before. We're often asked, or we've had a number of queries then around whether or not contracts can be suspended. Because if you think of it as an example I used earlier, and may not be so typical in the construction industry, where, as David says, things are going ahead and now there's extra days that have been regulated for when work can be carried out. But if you've got, for example, as I said, a waste contract where a premises is no longer trading as a result of a direction being told to close down, the question that we're often asked is, can we just suspend the contract for this period of the COVID pandemic, be that whatever period of time that's going to be? What we find with most contracts is that it's not usual to see a suspension for convenience clause. So rights of suspension, what we find, and with the contracts that we draft, invariably arise when one party is in breach. So in a supply contract or a construction contract, if there's breach by the builder or the supplier, that may give right to a contractual right to suspend. But we don't often see contracts that allow one party to just suspend for its convenience. And you can imagine that you'd be loath to enter into a contract that contains such a clause because, you know, how long might the party be entitled to suspend for? Who's going to pay for the costs of preliminaries that are stuck out on site during the period of the suspension? And if the suspension goes for a significant period of time, is there a mechanism that allows for any sort of price escalation that may occur during that time? So what we're finding when we're asked to advise in relation to suspension is that invariably, unless there is a breach by the other party, the suspension clauses are not giving us too much good news in terms of putting a contract on hold. What we do find with supply contracts where it's a regular supply, there are variations. There are variation regimes that allow one party to vary up or down by omission or addition the level of services that are provided. And what we're finding at the contracts that we're being asked to look at is that invariably that is the contractual way to go in terms of reducing even down to zero the level of services that may be provided during this period when the services aren't required because the facilities where the services are being performed are no longer open and access can't be obtained. The other clause that David mentioned is the force majeure clause. That's a clause that's enlivened by the occurrence of a defined event, which basically excuses the parties from carrying out their obligations, and that excusing of that may be on a permanent or temporary basis. So if there is a delay caused by a force majeure event, one party invariably is entitled to give a notice to the other party saying that they are excused from fulfilling their obligations, and then depending on the wording of the clause, whether they're excused from fulfilling them until that event is over or has moved through, or whether they're entitled to actually terminate the contract. The thing to remember about force majeure clauses is that they are a clause that relies on a defined event. So there's no such thing as a force majeure event. The force majeure event must be documented or defined in the contract. And that's where we see the typical clauses that we've seen. You know, a force majeure event is invariably an act of God. Now, David and I have had some discussion as to whether this coronavirus is in fact an act of God or whether it's caused by some other persons or countries. And I don't think we've seen anything, David, have we, that suggests one way or another as to whether or not it is in fact an act of God. But if COVID-19 was determined to be an act of God, then that would be a force majeure event that would allow one party to be, or both parties to be excused from fulfilling their obligations. Up until now, what we've typically seen is in the definition of force majeure events is that they've been centred around not only act of God, but events such as war and terrorism and flood and bushfires and natural disasters. And it's arguable that under those standard defined events that COVID-19 may not in fact be covered. As I say, there's some dispute or some debate as to whether or not it may in fact be covered as an act of God. So I think what you'll see moving forward is that you'll see force majeure events that will be defined to include pandemics, or a force majeure may be defined as compliance with a law or government order, such as the public health order that we've had, that basically was a direction from the government that said that pubs and clubs and amusement facilities and recreation facilities were directed not to open themselves to members of the public. We might find that those sorts of clauses now start to sneak their way into contracts as defined force majeure events, giving rise to one party to rely on that clause. The other thing to remember about a force majeure clause is that if it's not in the contract, then it's not available to the parties. You cannot imply into a contract a force majeure event. So again, sometimes we see contracts that have the force majeure clause with defined events expressly set out, and in other times in contracts that we've looked at, there is no reference or no clause dealing with a force majeure event. So to be note there that if there is no force majeure clause in the contract, then under Australian law, it cannot be implied into the contract. So they're the sorts of issues that we've been that we've been asked to advise on, as I say, in summary, mainly round extensions of time. There are people that are concerned about meeting dates for practical completion or dates by when certain parts of the construction project need to be installed, where they can't get supplies, and where, you know, in a lot of instances, or for a certain period of time, there's been no certainty as to when those materials and supplies would, you know, particularly if they're coming in from overseas, would land. Rights of suspension, as I say, invariably require one party to be in default, and that's not necessarily the case. Similarly, with rights of termination, termination often arises again as a result of default by one side, invariably of a substantial breach. What we see, and often what we try and draft into contracts when we're acting for principals, is a right of termination for convenience. So that would allow the principal to terminate the contract on the giving of a certain number of days' notice for his convenience. But obviously in this environment, people are not, where there are contracts in place, they're not looking to terminate them. They really just want to do what the rest of us are doing and just go into this period of hibernation with a view to having them revived when we come out the other side, whatever that may mean and whenever that may be. So really the option to terminate is not one that's necessarily being pursued, because the services are still and will still be required when we come through the other end. So that deals with suspension. Then, of course, force majeure, as I discussed. There's generally our finding is that the force majeure clauses don't cover pandemics, and up until now have been more aimed at, well, acts of God. There's some discussion about that, but certainly war and terrorism and natural disasters, such as, you know, the bushfires that we had over Christmas period. So they're the sorts of issues that we are seeing come up. We're still seeing claims being made under the Security of Payments Act. The parties are still enlivening and engaging with the Security of Payment Act on the commercial contracts if and when necessary, because as we've discussed on a number of occasions, that is still a very powerful piece of legislation that can help contractors get paid, or if not get paid, get a resolution of a dispute on the way through the project. So we're still seeing payment claims being issued and payment claims being resisted by the issuing of a payment schedule. So they're the issues that we're currently seeing in this environment.
Okay, thanks, Mark. Were there any questions from anyone?
No, I had a comment probably more than a question. It's interesting that the acts of the Chinese government are being considered an act of God. Or whether it's more war and terrorism than act of God.
Yeah, well, I think it depends on whether you're following the Trump line of thinking or or otherwise.
Yeah.
Okay. Well, if there's no questions, we'll finish off. Just before I go, you know, in this coronavirus year, we've all been at home for a long time. So, and no doubt you've seen a few memes and so on that have been coming out around coronavirus. I thought just to finish off, let's leave the law, and I picked a couple out. So I'm just going to share my screen, so you should be able to see this. That's number one for those of you at home, and then sorry, let me just get out of this. Where are we?
This is great stuff, this IT.
I'm assuming that worked.
Dear.
That's better.
There you go.
Good one.
That's it from the legal world, guys. Enjoy the rest of the meeting. Mark's going to hang around, but as I say, I've got to go to court. Surprise, surprise.
Enjoy.
Thanks, David.
Enjoy the visual.
Thanks, David.
Thanks, David.
Okay.
Thanks.